Good morning and welcome to HR Talk's Mandatory Vaccination webinar, where the Goldrush Arbitration Award shall be discussed, as well as what this means for employers and employees. This webinar will be led by Dunstan Farrell from Farrell Attorneys, of which HR Talk have had a long-standing relationship with. Dunstan has been a practicing attorney for 38 years and specialized in the field of employment law for 25 years. I shall now hand you over to Dunstan. Thank you.
So, good morning from a hot and sticky Durban. One wonders where we're going with this COVID thing, with the latest relaxations, schools back to normal, isolation becoming sort of a bit of a thing of the past. Only if you show symptoms do you have to isolate. But the cases are certainly interesting and far-reaching and will probably run all the way to the Constitutional Court. I'm going to deal with the CCMA awards. The first one is what I call the Goldrush Award, and the second one is the Ndaka Award, and then I'm going to give some of my own personal views and what I think is right and wrong with them, and what I would have done if I had been advising or the Commissioner on those matters. But I just want to start by saying, I put it out there, I'm a pro-vaxxer. And I am passionate about all of us getting vaccinated. I'm a great believer in herd immunity, and that I think that the current vaccination levels in the country are about 35%. Some European countries are about 85%. And I think if you were to have a referendum on vaccination, I think I would be very much in the minority. Just like with the death penalty, we don't have the death penalty in this country, and the Constitutional Court has ruled that the death penalty is unconstitutional. But I think if you went and had a referendum on the death penalty, the vast majority, 85–90% of people would be pro the death penalty. A democratic society where we can have democracy and the popular vote saying one thing, and the legislators and the Constitutional Court telling us something else. The issue of rights is a very sensitive issue, and trying to balance individual rights with collective rights, an individual's right not to be vaccinated, the collective right of a workplace to be safe, is a difficult issue. It's quite interesting. I appeared in a bargaining council a week before last. I asked my opponent if he was vaccinated. He told me he wasn't. He told me that his traditional medicine kept him safe and sound from COVID. The commissioner then said that she wasn't vaccinated either, and she wasn't vaccinated for religious reasons. So there's a wide spectrum of reasons why people do not want to get vaccinated. Political will from the government to legislate mandatory vaccinations, I think it's just a bridge too far for them. So I think it'll be left to employers, sports organizers, the Australian Open, Djokovic, we all saw what happened there, what would happen at the Olympics or Wimbledon or at the FA Cup final or whatever. I think there will be legislation in place in various countries that if you're not vaccinated or otherwise had a reason in the venue, and the same would apply to the workspace. And I think the Constitutional Court will find always that you have bodily integrity, that you can do with what you like with your own body, and no one can force you to do something else. And I think that will be a paramount individual right. We've also seen some slackening, loosening up of the regulations over the last few days. You don't have to isolate. If you're symptomatic, you only have to isolate for 7 days. You've seen schools opening completely, no rotations, no gaps. So things are moving quite speedily. I do think that there is a risk, and I just say to you, I've got Shante Lakshmi working with me, and she helped me with this presentation, but the responsibility is mine entirely. And it was her comment just before we went on air that the situation will be dramatic if there's a new wave and the next mutation is a far cleverer variant. The Omicron variant seems to be particularly mild and not particularly clever. So other rights, and we'll deal with them in more detail, is the Occupational Health and Safety Act and the Compensation for Occupational Injuries and Diseases Act. The other important issue is a risk assessment. So all workplaces have to do a risk assessment. And I think that it's very important and that employers need guidance when it comes to those risk assessments. And I think the Goldrush Judgment Award deals with that, and we'll deal with in detail what actually happened, because gets it absolutely spot on, and their advisors advised them well. They crossed the T's, they dotted the I's, but it was a very good way to get there. The other issue is the type of work that people do. So there may be the odd exceptions where certain individuals can stay at home. I was talking last night to a journalist at the Business Day, and Arena Holdings own implemented no vaccine, no work policy. And I was just debating with him the pros and cons. In fact, he was asking my views on the Mark Boucher saga. But he was saying that particularly in journalism, it's quite a collaborative type of work environment. Particularly young journalists need to be around experienced, wise, old journalists to bounce ideas off, to get leads, to think about an angle on a story. And sitting working at home is lonely, and you can't do that. So likewise, I think we implemented from the 1st of January, no vaccine, no work, because we also work in a very collaborative environment, and people need stimulation, they need to bounce ideas off each other. But I do think that there are exceptional circumstances where people can work from home. The other issue with working from home is the issue of discipline. And discipline works both ways. My own personal experience for the last 2 years is I don't know what a weekend is. I have my laptop with me and I just work. I work Saturdays and Sundays. Yes, I might on a Monday have a 2-hour break where I watch a bit of cricket or whatever, but I just don't seem to have working hours. But on the other extreme, there are other people, and with the greatest respect, excuse my discriminatory, but millennials seem to have a big issue with discipline. But that's my out there, as I'm a father of 3 millennials. And also just a heads up, coming up, Dr. in a debate under the auspices of SASLaw, she is taking up the Goldrush judgment and the argument that incapacity is the way to go to ensure vaccination in the workplace. And I am going the operational requirements route, and we haven't had an award or a judgment on that, but it is my view that that is the way we should go. I'm also a strong proponent of the exclusion route. And I use the word exclusion, and those of you who've heard me talk about strike management before, to lockout, and I will use exclusion here as opposed to suspension, because you'll see in the Ndaka award, the commissioner found that the exclusion of the individual was a suspension, and that's how the dispute found its way into the CCMA. I think that is the failing of that award, because I don't think it's a suspension. And if it's not a suspension, the CCMA didn't have jurisdiction to deal with it. So I think that may be in Ndaka security and creating space for a review. Having said all that, and having started by saying it's a very emotional issue, there are many human rights organizations, churches, political groupings, trade unions who are very opposed to the vaccination story. And I can see people taking up the cause, various NGOs or human rights bodies who are opposed to vaccinations will take this litigation on. So I don't think story, and I think particularly in the Labour Court, it may well be very judge specific. And I also see an opening in the what I call the Goldrush Award, where the commissioner seemed to get confused between discipline. He talks about a disciplinary inquiry being held, but the termination was for reasons of incapacity. If the dismissal is for reasons of incapacity, you don't go to the disciplinary inquiry because it's not misconduct. So I think there may well be a procedural gap in that award for someone to open the way in the Labour Court, as with the Ndaka judgment award. I don't think it was a suspension, and if I'm right about that, then the CCMA didn't have jurisdiction to entertain the dispute in the first place. But so be it. So I do see both these awards and any future awards, even if someone comes along with an operational requirements termination. And I must say, I don't know any of my clients who have on the operational requirements route, and speaking to colleagues, most of them agree with me and think that operational requirements is the way to go on that. But I do think that these awards will go all the way to the Labour Court, to the Labour Appeal Court, and on to the Constitutional Court. It's certainly not the end of what's happened. So those of you interested, we've got the SASLAW debate between Dr. Krobler and myself. I can't recall the date, but if you just contact SASLAW, you can probably get a link to that. You may have to pay if you're not a member of SASLAW. That's the South African Labour Lawyers Association. Yeah, so I now want to get on to the slide presentation, for which I want to thank Shantay and my officers. She's prepared it. It's quite interesting. If we just go to the first slide, and this is a quote: "If one wishes to be an active member of the community, then the incontrovertible legitimate interest of the community must trump the preferences of the individual." So this is a comment by the Deputy Judge President of the Gauteng Division of the High Court, Sutherland J., who has an employment background, so he won't let people into his. Judge Chetty is another one who won't let people into his court unless they are vaccinated. One wonders whether those directives from the judge sitting hearing a matter are lawful. I haven't heard anyone take them on. They are both very strong characters. I wouldn't like to argue that to be let into their court because I haven't been vaccinated. But I started this discussion this morning talking about individual and collective rights, and Sutherland here says quite clearly that the community rights must trump the individual's rights. As interesting, so we spoke briefly about Arena, the Business Day, Discovery, Old Mutual. Many, many big employers are now saying, no vaccination, don't come to work, stay at home. Okay, the Theresa Mulderay Goldrush Award. So Ms. Mulderay, she was a high risk, and they were confined to small spaces, and they had a mandatory vaccination policy. She raised her right to bodily integrity and refused to be vaccinated. Now, I agree with Mulderay. You have bodily integrity not to be vaccinated, but if that's the case, you stay at home. I cannot, and I don't think, that's why I started by saying, I don't think legislation forcing us to be vaccinated will be upheld by the Constitutional Court. I think this individual right to your bodily integrity will prevail. Having said that, I think employers, organizers of social events, pubs, restaurants, sports events, workplaces are entitled to say, you know, my office. As I said, Goldrush went to great lengths, and if any of you are looking to implement a no vaccine, no work policy, a good idea to read this award in detail. So the process, and those of you who are clients of ours, I circulated a memo to clients last week. There'll be a follow-up memo today. But in that memo, I circulated to clients last week of what the process included. There was reference to the Government Gazette on vaccination. A voluntary and mandatory policy was drafted. The policy was reviewed by EXCO. The employer's attorneys reviewed the draft policy before producing a final draft. Once all the risks and hazards had been identified, the policy was finally approved by EXCO. A mandatory vaccination policy was then established. The policy dealt with all the risks and hazards that the employees are exposed to. Before implementation, consultations were held with trade unions, employees. At the consultations, the benefits of the vaccinations were explained. Specialists were made available for the purpose of addressing questions that may be raised. These specialists included a traditional healer, a medical specialist, a lecturer in traditional health, a virologist, and a human rights expert. A copy of the mandatory workplace vaccination policy was provided to each employee. So you can see here that Goldrush went to extreme lengths before implementing the vaccination requirement. So you could apply to the committee if you wanted an exemption, and in Mulderay's case, the exemption committee identified her as a high-risk individual who interacts with colleagues daily whilst on duty in confined and uncontrollable spaces. And her case relied very much on Section 12(1) of the Constitution, which provides that every person has the right to bodily and psychological integrity, which includes the right to make decisions concerning reproduction, to security in and control or scientific experiments without her consent. She felt that she was under extreme social pressure and emotional discomfort, being subjected to deciding between her livelihood and accepting the vaccination. She also said that she had complied with the COVID protocols strictly. We go on to the mandatory vaccination. The next slide, the mandatory vaccination in the workplace. Section 8 of the Occupational Health and Safety Act states that an employer is obligated to take reasonable steps to ensure that the workplace is safe and risk-free to health of all employees. If an employer decides to mandate COVID-19 vaccinations, a link must be established between the level of risk related to the employees who are subject to the policy. This mandate must be by means of a means to reduce the risk of transmission. The risk to mandate vaccines in the workplace. I do think in a factory environment where there are lots of people, or an office space, open plan spaces, once you've done the risk assessment, I don't think there's any doubt that vaccines are the way to go. Section 8 and 9 of the Occupational Health and Safety Act requires every employer to conduct a risk assessment. It's essential when managing risk assessments that employers notify the employees that mandatory vaccinations are based on the high risk employees being within the definition of vulnerable employees. Who is a vulnerable employee? An employee over 60 years falls into this category of high risk, or severe COVID symptoms, or death if infected. An employee with known or disclosed health issues or comorbidities or any other illness which places an employee in a position that increases complications of death in comparison with employees who contract SARS-CoV-2 virus will be a vulnerable employee. The lawfulness vaccination policy is to ensure that the policy is lawful, reasonable, fair in respect of the employees. The limitation of employees' rights may be limited in terms of Section 36 of the Constitution. I, as an employer attorney, believe that the Occupational Health and Safety Act and the COIDA Act trump everything in terms of you've got to provide a safe working environment. Okay, the legislation around mandatory vaccinations, we've spoken about the Basic Conditions of Employment Act, and the Labour Relations Act also comes into play. How to implement a mandatory vaccination policy. I've dealt with that in some detail, referring to my memorandum to our clients of the 26th of January, but we've set it out again in this presentation. The detail is spelled over there in the next few slides. Then employee support. Paid time off for employees to get vaccinated during working hours. Must submit scheduled vaccination, proof of scheduled vaccination to the employer. Leave may not be deducted from employees' contractual leave entitlements. Employees' leave must be treated as unpaid if no proof is submitted, and employees' absence may be regarded as unpaid leave. If employees suffer from the side effects of COVID-19 vaccine, such employees will receive paid sick leave in terms of Section 22 of the Basic Conditions of Employment Act. A vaccination certificate must be submitted. Sick leave is for a claim of compensation in terms of the Compensation for Occupational Injuries and Diseases Act, COIDA. Okay, so back to a summary of the what I call the Goldrush Award. The Commissioner there found that on the basis of incapacity, Goldrush were entitled to terminate Mulderay's contract of employment. The weak link, as I see it, is that the Commissioner found that a disciplinary inquiry had taken place. And I take you back to the basics. Have a look at the Code of Good Practice on dismissals, and there's a clear distinction between the various processes to follow for the various reasons for dismissal: incapacity, poor performance, misconduct, strike, operational requirements. Each have very distinct procedures. Where you refuse to undergo or to have a vaccination is not misconduct. You have that right not to be vaccinated. I cannot give you instructions to be vaccinated is certainly not misconduct. It may well be incapacity, and I look forward to debating the issue with Dr. Krobler in the next week or so. As I say, I think the safer route to go is operation requirements. The Ndaka Security Services, now this award came out last week, and Ndaka Services provided services to vaccination requirement. So SASL required anyone attending their various sites to be vaccinated. Ndaka was supplying services. De Kock was one of those people. Kock refused to be vaccinated, so Kock was told to stay at home. And Kock, interestingly, also was unwilling to submit weekly COVID tests at his own expense. So there was a gap for Kock just to get tested weekly if he didn't want to be vaccinated and he wanted to work. The CCMA Commissioner in the Kock arbitration said that Kock's inability to gain access was a suspension, and that fell under Section 1862B of the Labour Relations Act. So that opened the door, and I was explaining to one of the article clerks in the office here, to get into any court, CCMA, Labour Court, Magistrates Court, High Court, you need a cause of action, particularly in these what we call statutory bodies like the Magistrates Court or the CCMA. Joe was horrible to me, therefore I want you to hear my case. You have to have a cause of action. In civil law, we talk about cause of action in delict, in other words, negligence. You negligently crash into my car and cause damages. or contractual, you agree to pay R1 million for my house, you reneged on the agreement, I rely on the agreement. Those are causes of action. In the CCMA, we have causes of action: unfair dismissal, misconduct, incapacity, poor performance. We have the unfair labour practice jurisdiction, which is very specific. Failure to fulfill the terms of the contract of employment. My refusal to allow you to enter my offices to work because you haven't been vaccinated is not a cause of action in the CCMA. I put out there, I may be provocative when I say that, but I don't think that it should go on CCMA, and I would need to just research it a bit further and see. The Labour Court has very wide jurisdiction in dealing with employment-related issues, and maybe there's a door open there. So maybe Cox, sure, as I said, there are human rights organisations, trade unions who gladly take on this issue pro bono or pro amico or pro deo, to take it all the way through to just test the law. The Commissioner said that there was no possibility of accommodating COC because particularly SASL had said that no one can enter its premises. There may be an argument not as requiring such levels of vaccination, and maybe there was space from elsewhere, I don't know. But I use the word that I think there was some legal gymnastics to get this matter before the Commissioner. The award, the obligation of mandatory vaccination circumstances supported by a thorough risk assessment. So both awards go back to this risk assessment. And I think that you need to be guided and professionally helped in achieving this risk assessment, because if we don't do it properly, or in due course in the Labour Court. So currently, relying on both these awards, employers may deny access to unvaccinated employees, and they may terminate their contracts of employment. But be careful. So let's just deal with the refusal to vaccinate briefly. Employees have the right to refuse to be vaccinated due to medical and constitutional reasons. Clause 5A2 of Annexure C of the Directive. Employer must apply the procedures prescribed in Clause 5.2 of Annexure C in the event of an employee refusing to be vaccinated. An employer must counsel the employee. In the event of medical contraindications with regard to the vaccine, the employer may refer the employee for medical evaluation. The employer must reasonably accommodate the employee if necessary. Reasonable accommodation includes, but not restricted, requiring the unvaccinated employee to wear protective while conducting work, permitting the employee to work in isolation and away from other employees in the workplace, adjusting duties of employee in an attempt to minimize close contact, executing more spaced working hours, insisting that frequent COVID tests of unvaccinated employees, conducting tests prior to each workplace appearance or visit to the client. Now, I wonder whether the next test is going to be on the basis of discrimination, that vaccinated and unvaccinated people are treated differently in the workplace. Section 14 of the Occupational Health and Safety Act. Employees have a general duty to take reasonable care for the health and safety of themselves and other persons that they may be in contact with. Communicate with the employer to help the employer when executing their duties in compliance with the obligations of the Occupational Health and Safety Act. Execute any lawful order given to them by the employer. Obey the rules set out by the employer, which are in the interests of health and safety. Occupational Health and Safety Act and the Directive 13 ensures that an employer and employees are legally obligated to ensure health and safety in the workplace. Clause 13 of the Directive provides In addition to the obligations of employees under the Occupational Health and Safety Act, every employer is obliged to comply with measures introduced by the employer as required by these directions. Where the employer has applied procedures as a method of complying with the directive, its employees are under a legal obligation to abide by such procedures. Failure or refusal of the employees to abide with COVID-19 procedures subjected to disciplinary action for not obeying a lawful and reasonable instruction. Procedures must be lawful and reasonable. I just want to touch on constructive dismissal cases. Some clever employee may well resign as a, so we seem to have got a slide behind there. No, we could termination as a result of that. Yeah, there are constructive dismissal claims. So some clever employee may say, relying or the demand or the requirement that employment intolerable and that they are therefore forced to resign and that is a constructive dismissal. I don't suggest any employee try this. Constructive dismissal cases are becoming harder and harder in the CCMA for employees, and the compensation at best for an employee will be 6 months. And remember, you don't get your job back, but you may, at best, if you've got 30 years service, you may well get 6 months remuneration as compensation. But I certainly don't think the employee will be successful in the first place, because by intention to terminate contracts of employment. So be very careful, any employee who wants to go that way. I just want to go back, and as I said, my view, and I think the correct way to go is the operational requirements route. And one must bear in mind that operational requirements, Section 189 of the Labour Relations Act, isn't just about financial issues. So just because you are in financial difficulty, you want to retrench, it talks about technical, economic, and other place. And I think that the need to have all employees vaccinated in a workplace may well be an operational requirement, and therefore refusal to do so may open the door for an operational requirements termination. But I just want to warn employers about a number of issues. I am fearful, for want of a better word. I warn caution always about termination lockouts. You hold a gun to an employee's coming in to dismiss you. That is a unilateral. It's a termination lockout. Or if you do implement it, it's a unilateral change to terms and conditions of employment. And the Eveng judgment, the recent Constitutional Court judgment of Eveng, I think it's about 18 months ago, Eveng and NUMSA, goes against my argument. But I think, and I presented a paper at the SASTOL conference last year on the Eveng judgment, and I think it was very fact specific. In that judgment, NUMSA had behaved badly. They had an agreement on changes to terms and conditions of employment. NUMSA reneged on that change, and therefore a retrenchment followed. And the Constitutional Court found that Eveng had done nothing wrong. But I just warn, I am very cautious. I'm not a great lockout believer, and I think that there are great risks with termination lockouts, despite the outcome of the Eveng dispute in the Constitutional Court. But I do think that operational requirements may be a better way to go than incapacity or that simply exclude you from the workplace because of your refusal, because I have a requirement to provide a safe working environment. As I mentioned earlier, I think unfair discrimination may be an opening for employees who are dissatisfied and think that the employer is favoring vaccinated employees or making life difficult for unvaccinated employees. That's my story. Interesting. And I wonder whether my provocative statement for the day is, I wonder whether all this becomes very academic, whether South Africa is actually at the forefront of the world. One sees all the mistakes that Boris has made. You've seen the rioting taking place in Holland. But maybe the virus is just simply fizzling out on its own accord, and that maybe we needn't have got vaccinated. Maybe there would have been more deaths. I do say that one death is a death too many. I don't know what the stats are today. We seem to be hovering between 50 and 100 deaths a day. Someone said to me, well, how many of those deaths are just from flu? How many people actually test positive or don't test positive, but actually have COVID and are not tested? But interesting times. Thank you. I'm happy to take questions.
Okay. Hi, Dunstan. I have a question. Since changing your terms and conditions of employment, do we need to amend our contracts of employment to make provision for the mandatory vaccinations?
By amending terms and conditions of employment, you may run the risk, and it's been of interest. So NUMSA supports vaccination. I suspect, and I refer to them as renegade trade unions. So these charismatic unions like African Meat Industry Trade Union, I suspect if they hold a majority of employees in a workplace and you said, I'm changing your terms and conditions of employment to make vaccination mandatory, you would have a 48 hours notice and you have a strike, and the strike will actually change terms and conditions of employment. Likewise, I think if you suddenly excluded specific employees for being unvaccinated, you may well provoke an unprotected strike if in a factory. But I certainly don't suggest changing terms and conditions of employment. And I think just based on the Occupational Health and Safety Act, the basis is I need to provide a safe working environment. If you're unvaccinated, you're a risk to everyone else, so stay at home.
Thank you. Do we have any other questions for Dunstan?
Very happy. If any of you got questions you want to ask privately, please send me an email and I'll get back to you within 24 hours. Vicky said to me there were about 90 people attending this morning. I'm surprised that there are no questions.
So we've got 52 participants. Nothing's come through on the chat yet.
Yeah.
I see there's one hand that is up. I'll allow the person to speak. Thank you.
Good day.
Hello, Michael.
How are you? Thank you so much for the information.
No problem. Pleasure.
I just want to find out something specifically in relations to, you spoke about that if you don't have COVID, if you have COVID but no symptoms, you don't have to isolate. Does that mean the employee can still come to work if they don't have symptoms?
I didn't get the question. So if you don't have symptoms, you don't have to isolate. Yes, and you can go to work. Yeah, I think it's crazy, but that's what they've decided. Yeah.
Okay, that's fine. Thank you so much.
Yeah. And do you want to see? Sorry, I pulled it out this morning. So this is from the Department of Health. Cabinet approves changes to adjusted alert level 1 regulations. Cabinet held a meeting today. Based on the trajectory of the pandemic and the levels of vaccination in the country, Cabinet has decided to make the following changes. Those who test positive with no symptoms do not have to isolate. If you test positive with symptoms, the isolation period has been reduced from 10 days to 7 days. Contacts do not have to isolate unless they develop symptoms. The rationale for these amendments is informed by the proportion of people with immunity to COVID-19, which has risen substantially, exceeding 60 to 80% in some sero surveys. Full-time learning in all schools, primary, secondary, and special schools will return to daily attendance. Regulatory provisions for social distancing of 1 meter for learners in schools has also been removed. So that was the 31st of January.
Thank you so much.
Okay, Dunstan, we have a question from Natasha. Have the cabinet decision on the reduced isolation requirements been gazetted as yet? If not, should we wait for the gazette prior to implementing?
I don't get the first part of the question.
Sorry. Natasha has asked, has the cabinet decision on the reduced isolation requirements been gazetted as yet? If not, should we wait for the gazette prior to implementing?
No, I think that's it. They've decided that. Yeah, I wouldn't worry about the gazette and get on with it.
Okay, we've got another question from Meryl or Mal. Given the change in isolation, despite positive status, do you still believe that mandatory vaccines and exclusion of employees is warranted?
I do, but that's and I'm not a medical doctor, but I personally believe that vaccination is important, and I think we need to develop the herd immunity. I'm going to go. My booster shot is due, and I should have gone last week. I didn't get there last week, but I'll try maybe even directly after this presentation. But I speak to an expert, and I think most of the experts would probably agree with me, being arrogant.
Thank you. We've got another one from Asasipo. Is the decision to allow asymptomatic individuals into the office backed up by studies of no transmission to vulnerable individuals in the workplace?
And we have some of the top experts in the world here in South Africa. I'm sure the cabinet decision would be backed up by science. I don't think they would have just decided that. I also think that it is we need to get this economy up and running again. And the sooner we all get back to normality, the better. So I think it's a combination of science saying we're getting on top of the virus. And with that, we need to get this economy up and working again. People need to get back to work. We need to be creating jobs. We need to be paying salaries. We need to be paying tax. So
okay, another question has come through from Glynis. In terms of third-party suppliers' contracts being terminated due to third-party employees not being vaccinated, how would you recommend the third-party supplier deal with that situation?
So I don't know. We have a no vax, no enter policy here at work, and that the delivery guy is unvaccinated, and we say to him, well, you can't deliver here. That becomes the third party, the stationary people's problem, because we just say we're not having unvaccinated people at the office. And that's what happened in the Cox situation, where Ndaka provided services to Sasol. Sasol have a policy, no vax, no enter, and so Ndaka suspended, I don't think it's the right language, but said to Cox, you can't come to work until you get vaccinated, because our client, Sasol, have a
Okay, and then we've got another one from Michael. The isolation period is regarded as sick leave. Is that correct?
The isolation period, yes, that's correct.
Thank you. Are there any further questions?
Thank you, everyone. Have a great day.
Thank you so much, Dunstan, for an informative session and sharing your insight. The presentation will be made available. Thank you, everybody.